Free trade agreements shape the landscape of international commerce, but how much do we really understand about them?
Wow, that sounds intriguing. What exactly is a free trade agreement?
A free trade agreement, or FTA, is a pact between countries to eliminate or reduce trade barriers, ultimately promoting trade.
And it's fascinating to note there are two types: bilateral agreements between two countries and multilateral agreements that involve three or more. Each has its own complexities.
So, does that mean there's a different level of negotiation difficulty with multilateral agreements?
Absolutely. Multilateral agreements are much more intricate to negotiate since they involve multiple parties with varied interests. This begs the question, how do these agreements impact tariffs and trade barriers?
FTAs typically reduce or eliminate tariffs, but they often include additional clauses related to investment and intellectual property, making them quite comprehensive.
That's a lot to unpack. How do customs unions compare to free trade areas in this context?
Great question. While customs unions enforce identical external tariffs, free trade areas offer more flexibility, allowing countries to set their own tariffs with non-member countries.
This distinction is crucial for understanding trade dynamics and could lead to unexpected outcomes in international trade.
When did these free trade agreements really start to take shape?
Interestingly, the term free trade agreement was used as far back as 1877, specifically in relation to the Australian colonies.
And later, with the establishment of the World Trade Organization, countries increasingly turned to FTAs. But there's a debate whether the WTO has effectively promoted trade dialogues or not.
That's fascinating, but why do some consider the WTO a failure?
Some argue it has stalled meaningful negotiations, while others commend it for preventing trade wars. It's a double-edged sword.
Speaking of legality, what legal framework surrounds these agreements?
Under WTO law, FTAs are seen as an exception to the most favored nation principle. They can grant preferential treatment among signatories, but can't harm non-parties.
Article 14 of GATT lays out conditions to establish an FTA, ensuring that pre-existing regulations with non-parties are not more restrictive.
So, are there any legal repercussions if these agreements aren't followed?
That's where it gets tricky. Disputes within FTAs may not be settled through the WTO's dispute settlement body, but this doesn't guarantee immunity against WTO scrutiny.
That uncertainty adds a layer of complexity for governments as they navigate these agreements.
I've heard about trade diversion and trade creation, but what do they really mean?
Trade creation leads to scenarios where trade shifts from high-cost producers to lower-cost ones within the FTA, which boosts national welfare.
Conversely, trade diversion draws trade away from efficient external suppliers to less efficient internal ones, which can be detrimental, especially for consumers facing higher prices.
But you mentioned that trade diversion doesn't always harm national welfare?
Correct. If the diversion volume is small enough, it can even enhance overall welfare, but it's certainly a balancing act.
This is turning into a complex web. So can FTAs actually be considered public goods?
Economists are exploring just that. The embedded dispute resolution tribunals offer a crucial public resource for clarifying trade laws.
Plus, newer FTAs are becoming deeper, addressing a broader range of regulations beyond just goods.
What does that deeper aspect mean for international trade?
It means FTAs now cover services, e-commerce, and much more, making transactions cheaper and offering broader benefits to member countries.
How do countries ensure that non-members don't benefit from these agreements?
That's where rules of origin come in. FTAs need to define which goods qualify for preferences, ensuring that tariffs only reduce for genuinely produced items.
Exactly. This prevents non-members from capitalizing on lower tariffs simply by importing goods through a member country.
But what happens when there's a need for inputs from outside the FTA?
They'll incorporate substantial transformation criteria, meaning that to qualify for benefits, there has to be enough processing done within the FTA parties.
This leads to a lot of strategic decisions about sourcing and will certainly impact trade patterns moving forward.
Wow, this is incredibly enlightening, but I can't help but wonder, what happens if new trade disputes arise in the future?
That's a whole other discussion. Listeners, if you have any insights into future trade disputes or aspects we didn't cover, feel free to share your thoughts in the comments.
Definitely. Engaging with these ideas could open up new dialogues about the very fabric of international trade.